and Human Services Committee to order. We have one bill today, and before we do that, if I can call upon Senator Hatchett, since he's joining us back for his third meeting. So if you would mind, bring us to prayer, and then we'll get the meeting going.
Absolutely. Let us pray. Dear Heavenly Father, we thank you again for waking us up this morning. Thank you for putting us in the position where we can do your will. We ask for wisdom, and we ask for your guidance as we move forward and continuing to advance the state of Georgia. In Jesus' name I pray. Amen.
Thank you, Senator. And right on key, Senator Robertson has had a busy day today since about 7 a.m. and then I was in a meeting with him at 8 a.m. and here he is at 1 p.m. and has Senate Bill 116. That is our only bill today. We do have 4 people to speak. I'll let Senator Robertson present the bill, and then we can have testimony, and then we'll have the will of the committee. If that's the order that we proceed, hopefully that's the way we will proceed. And we're on LC 338570 without an S. So it's the first bill I've seen in a while without a substitute. So I'm sure that Legislative Council number 33 was much appreciative on that one. The floor is yours. You're at the podium there. Thank you.
Yes. Senator Kirkpatrick, are you comfortable with me taking my mask off while I testify?
You can take my mask off.
Thank you.
I'm 60 years.
Yes, ma'am.
And she's had it.
Mr. Chairman, I want to thank you for this opportunity to come in here and have a hearing on this legislation. It's an extremely important piece of legislation to me. I think those of you who know me in my personal life understand how important addressing the infant mortality rate and the maternal mortality rate here in Georgia is to me, especially with some of the one in particular, one of the counties I represent is one of the poorest counties in the state of Georgia and has some extremely disturbing numbers when it comes to the maternal mortality rate and infant mortality rate. So I'm hoping that SB 116, once passed, will go a long way in addressing some of those issues. And a brief summary is what SB 116 does is it creates a new code section in Chapter 5 of Title 49 that deals with social services, and it creates a maternity supportive housing residence. And what this is pretty much defined as a residential home that is owned and operated by a nonprofit. And the purpose of this home is to allow pregnant ladies 18 years or older who need a place to go, a place to live, especially during their pregnancy. It gives them a safe haven to go to. Once they're there and once their child is born, I want to point out, if they already have children, those children are allowed to go with them and live in this facility. And once the new baby is born, the mother, the new baby, and any pre-existing children are allowed to stay in the residence up to 18 months for the opportunity of bonding between the child and the mother, and the child and the other children if there are other children. We have written the language, I feel, it's a little different from when we first sat down because I wanted to try to exclude government interference as much as possible. Currently in the state of Georgia, I know that there are homes very similar to this that exist. They allow younger ladies that are pregnant to come in. They have long waiting lists. Sadly, the information I was given is one of the reasons they have these long waiting lists is because a lot of their current residents are young women who are part of the foster care system who have become pregnant while in the foster care system. And so they take them out and put them into these homes, which as a law enforcement officer, I'm always concerned when people define pipeline to prison in a very narrow way. There are many pipelines to prison. And not giving young pregnant females who are treated much differently than males. Males find it a lot easier to transition back into the communities, has been my experience, especially from the criminal justice system, than females do. And so I just see this as a safe haven with as little government interference as possible to allow these mothers to have and raise their children in a safe place and regain their confidence if need be to get them back out into the community. And I will, I know there are a couple of people that want to testify for, and I believe there's probably a couple that want to testify against, but I would appreciate any reasonable consideration on this bill, Mr. Chair.
Thank you, Senator. Do you want to entertain questions now, or if we have any questions, or do you want to let them testify? I'll tell you what my thoughts are. If we have just some basic questions that we can clarify here and then get people to testify if we have questions to follow up. I don't
At the
think
will
we're
of
in a
the chair,
quick
I'm
timeline.
I will not give a civics lesson like you and I had this morning, though. I will tell you that, sir, from our University of Georgia professor. He's a lot smarter than me.
I appreciate that. Thank you. And, you know, seeing that he'll be voting on this bill, I'm glad you're very gracious with that. Thank
He's
you.
my hero.
That's right.
A mentor, an elder that I look up to.
All right, so just for my point of clarification, the state does, for 18 and under, already have this in law, or this is sort of the safety net for 18 and under. This is for 18 and above. 18 to, I'm sorry,
There is no limit.
there is no limit.
No, sir.
Okay, and, okay, so I see that there is some preliminarily aspect relating to the federal law relating to zoning, and could you comment on that? Have you seen that? I
It
don't
was
wanna-
just handed to me as I
Okay,
was coming
so why
in.
don't instead
Yeah.
of springing that on you?
Yes, sir.
Let me see if anybody else has any other questions besides relating to that, and then we can circle back on that since that was just handed out. We have Senator Kennedy on 2.
Thank you, Mr. Chairman. Senator Robertson, thank you for bringing this. I think I understand the purpose and am supportive. I guess just some basic questions, sort of like what the chairman was asking. So we don't have such something like a maternity supportive housing residence reference in our code now. Is that right?
That's correct.
Okay. And would any state funds be involved in this?
Absolutely not.
And I note that it's on line 15, it's nonprofit. What is the purpose in needing to codify this type of home, given that it's not going to be funded by the state and that it's nonprofit? Is the recognition of a maternity supportive housing residence something that enables some other kind of protection?
It does. It protects the residents that are there. What we've found and what we've ran into and had to investigate is there's other type of group homes that have been allowed in Georgia, and what we have found is there have been some bad actors that open up these group homes in neighborhoods. Some of them are for some of the mentally and physically disabled juveniles, some for older individuals, and what they do is they move them into these substandard type living facilities in order to get money from the federal and state government. And basically what we're doing is we're trying to allow nonprofits that want to go into residential areas and non-residential areas, and they want to have a structure that has been past the normal residential inspections to house this many individuals and just be a part of the community and not be dependent, not go out and shop for individuals to come in there so they can profit off the circumstances of the individuals that need a place like that to live. We have seen, and I think it was you, Senator, that made the comment about sometimes about how I state things, and while I take that as an honor that you feel that way, I think that we see the way it's set up right now in Georgia, it does not benefit those individuals in such weak and vulnerable positions. And so we wanted to set something off to the side, especially for this population. So we're not asking the state for anything, and I understand now that I've started scanning through this, and I see that ACCG is in opposition, and there's no shock on my face that they are. But I think this is the safest way to protect this community from predators that we've experienced in the past with others.
Mr. Chairman, a few more, if I may ask.
Yes.
Senator, if you would look at lines really 15 and 16, this is just a question, it's not a complaint.
Yes,
but, so it says that the home, on behalf of a nonprofit, will serve up to 6 pregnant women aged 18 years or older and their children at any one time. And I was wondering, should perhaps that be and their minor children, or is the concept that the pregnant mother and her children would have adult children in this facility? And if so, if that's what you plan and that's what you want, I'm probably okay with that. But if not, that might be something you want to give some thought to. Would you have adult-aged children in the home?
That's why I consider you my lawyer, sir, because I think that's something that does need to be adjusted. That's a good
Okay.
catch. Yes, sir.
Okay. Just a couple more, Mr. Chairman, if I may.
Yes.
Line 36, Senator, one of the obligations in line C, one of the requirements, rather, is that they have property insurance coverage on the residents, which covers the residents, newborns, and other children. And I'm wondering what you're trying to achieve there, and I'll ask maybe some of the other counsel on the committee with me. When I read property insurance, I typically think of property and casualty insurance, but then it requires, quote, coverage of the residents, newborns, and children, and that kind of has a different connotation, one of personal injury or liability. And I'm wondering if we don't need to be specific as far as exactly what kind of insurance would be required.
The primary purpose of it was to make sure that they had the proper insurance that would cover, in liability is the correct word for all the residents living there. I don't want to make this an easy jump for anybody who sees this as a profitable business that they may be able to jump into and take advantage of some individuals. So it's basically, homeowners insurance on steroids to the most part, but you do have but with the nonprofit designation, setting it up, it would be similar, I would think, to the type of insurance that maybe the Ronald McDonald House and some of the others are required to have to protect the individuals that stay there for long periods of time.
Okay, and then lastly, Mr. Chairman,
Yes.
I note that on line 14, maternity supportive housing residence is a defined term, and those 4 words as a defined term are used throughout the bill. But when we get to subsection D, it says nothing in this code section shall be construed to require a maternity home. And the word maternity home is used on line 46 and on line 48. And is a maternity home something different from a maternity supportive housing residence? And if it's not supposed to be, I think maybe from a drafting standpoint, we might want to keep the same defined term phraseology in paragraph D, if that's what you're trying to do.
So let me interject here. If we could get Ms. Howerington, who's the LC 33 here, to help us with that.
Okay. Yeah, maternity home is actually a separate thing already in code, and it's licensed by Department of Human Services. So it's basically saying, and that they actually provide a lot more services than these homes under this bill are going to provide. So it is a different thing, and we're saying that
Okay.
they don't have to get the registration because they're already licensed anyway.
Gotcha.
So it's a separate entity.
Okay, great.
And-
Thank you. That answers that. Thank you, Mr.
And I
Chairman.
believe those are the homes I was speaking of earlier
Right.
that the state currently operates.
So
Yes,
let me make sure we're clear here. So line 16's, it sounds like we may need to make some minor adjustments here. I don't mean a play on words there, but 16 is probably going to have to include minor children. And
Yes, sir.
then on line 36, we're going to have to define the type of insurance
Yes, sir.
there. Okay, gotcha. Okay.
Thank you, Senator, for bringing the bill.
Thank you, Mr. Chairman.
Senator Hatchett and then Senator Jackson. All righty.
And Mr. Chairman, I just have a kind of a point of clarification. Is this intended to include women who are married and have a relationship with a husband? And would that husband be allowed to live, if they're homeless, would he be allowed to live in the house? Or is this specifically just to house women who, who are single, or just house the women and their children? Is that the
It's
intent here?
just to house the women and the children. If it would be none of the state's concern if there was a spouse involved. I've come in contact with many females who have been married for 15 years and haven't seen their spouse in 13, and they're out and destitute and looking for support because, to be honest with you, they can't afford to get a divorce. This right here is just for mothers and their unborn children and the children, the minor children that are with them. So no. And as far as the regulations of visitation and stuff like that, I think it talks in here about the rules and other issues related to that. Has written policies and procedure. I'm sorry, Senator, line 34. Has written policies and procedures for admission, intake, and record keeping, is in compliance with applicable residential building codes, and then the insurance question that Chairman Kennedy was discussing.
Thank you.
Yes, sir.
I guess the question is on that, and just for a point of clarification, is that, I mean, it does say pregnant women 18 years and older, and they're, what we'll say, I guess, minor children. It doesn't say husband, but if
It doesn't say spouse at all.
it doesn't say, but if we want to make that clear, and if that's unclear to us, it may be unclear to others. So that's something maybe want to think about. I'm just throwing that out there.
Yes, sir.
So Senator Jackson is at 10.
Thank you, Mr. Chairman. Senator, now, don't we already do a lot of this with rape crisis centers and battered homes for women? Don't we already do some of this with group homes?
We set something up for that. The groups you mentioned, those are privately addressed homes. Nobody in the neighborhoods know that those are what those are, in order to protect the victims that are living in those homes. But yes, sir, we do have establishments that would look very much like this. But again, their population, like you said, is an entirely different type of population, and the security and protection around those homes is much, much greater, to the point that most law enforcement officers in any community could not tell you where those residences are, because it's just the way that you find out who knows where they are and how they get the victims to that resource.
Follow-up question, Mr. Chairman.
Yes, sir.
So this language now is just for residents, homes for pregnant women?
Operated by nonprofit organizations, yes, sir.
Can an individual operate one also? Or they have to establish a nonprofit?
They have to be a nonprofit, yes, sir.
Right. Thank you.
And the reason it says nonprofit and doesn't attempt to describe nonprofits, when I was originally in conversation, somebody mentioned the phrase religious organization, and I asked them to define that. And we understand that, religious organization is a very broad term, and I think nonprofit is much stronger.
Dr. Al.
Thank you for bringing this bill. I have a question about this language that local government bodies are prohibited from subjecting maternity supportive housing to rules and ordinances beyond what would be subjected to a single-family living situation. You had referred earlier
Hey,
to...
If you'll help me by what line you're on.
Oh, sorry, I'm just
Senator,
reading
sorry.
the last line of this.
Oh, you're on the summary?
Yeah.
Yes, ma'am.
The Cliff Notes version. You had referred earlier to some similar housing or institutions in the past being run by bad actors, especially those that are receiving funding. Is there a concern, given that this specifically eschews government oversight for these residences, that there could be potential for abuse or similar types of bad actors in this setting, given that there is no sort of government oversight?
Senator, the amount of government oversight at the facilities I referenced earlier, actually, because of the bureaucracy, can actually perpetuate the abuse and mistreatment because of the profitability that's built in, and with a government such as those that manage the state-owned homes, they're overloaded, and so sadly they have to find the squeaky wheel, and many times that leaves others exposed. And what we found was, once we got all those government agencies in a room, nobody was exactly sure who was responsible for what part of those other type homes. And this was in Columbus and in Muskogee County. And this right here, we feel that we've had much more success with nonprofits that are not affiliated with any government agency.
Just a follow-up point. I guess my only concern is that if you're looking at pregnant women and minor children living in the house, that this is to some degree a uniquely vulnerable population, and I wonder that having that lack of government oversight, even taking the profitability element out of it, leaves them bare for abuses within these residences. That's my only point. Thank you.
I think the value of a nonprofit and being involved in establishing a nonprofit within a group I formerly represented, it's an extremely valuable designation, and it's fragile, easy to lose. I'm sure that one of the attorneys on the committee could tell you that once you lose it, it's tough to get back. And based on evidence of other types of entities operating these or individuals operating these, I think this would be the safest way. And when I say port in a storm, it's exactly what it is, because without things like this, those ladies are left out there very extremely vulnerable, as are their children.
Thank you. So if there are no further questions, we'll have the folks who are socially distanced in the hall. We have Mike Griffin, Elizabeth Reed, Beth Haythorne, and Larry Ramsey. And I apologize if I did not pronounce any of those names correctly. But let's have them come in and have someone in the chute there waiting, please. If Mike Griffin can come forward. There we go. Thank you. And then we have Elizabeth Reed, who's next. Hey, Ms. Griffin, if you would just identify yourself and let us know who you're with. We really appreciate that.
Yes, sir. Thank you, Mr. Chairman. Thank you, committee, for allowing us the opportunity to testify on this bill. My name is Mike Griffin. I'm the Public Affairs Representative for the Georgia Baptist Mission Board. And Georgia Baptist typically represents somewhere around 1.4 million Georgians, up to 3,600 churches. We're the largest denomination in the state. And this is some legislation that we think is very important. We appreciate Senator Robertson sponsoring this bill in the Senate. Our executive director, Thomas Hammond, changed the strategy of what we call Mission Georgia in our denomination better to be able to mobilize our churches to address critical needs such as pre- and postnatal care for mothers. The sentiment behind this legislation, we believe, reflects the heart of Georgia Baptist to care for the life of the unborn and the life of the mother. The legislation will create a way for individuals and families in our churches to open their homes to care for expectant mothers holistically, just as many have done in foster care. And legislation like this, we think, can better position, hang on just a second, can, someone's sending me something here, getting in the way of my notes. We believe this legislation will create for individuals and families in our churches to be able to open their homes to care for expectant mothers holistically, as I was saying, just as many have done in foster care. Legislation like this can better position our churches to respond to a critical need in Georgia. We believe the environment of our churches will help change the involvement of our churches will help change the status of Georgia as being one of the deadliest states for expectant mothers. We're currently working with the Atlanta Morning Center to highlight ways churches can serve this need. We're also beginning the conversation with Hebron Baptist Church about their desire to meet this kind of need as well, which is a large church in our state. And the Georgia Baptist Mission Fund, or Georgia Baptist Mission Offering Funds, are being designated to strengthen efforts of churches and nonprofits that are trying to serve in meeting this tremendous need in our state. And so we would certainly appreciate your favorable vote on this kind of legislation. We really think it could make a big difference in our state. And at Georgia Baptist, we want to do like we all, I believe, should want to do, and that is put our money where our mouth is, and that is we talk about caring for people. We want to do a better job of caring for mothers and children in our state. And with a denomination this large, we should be doing more, and we want to help in foster care and adoption. We just want to make a bigger difference in loving people and caring for our mothers and children. Thank you, Mr. Chairman.
Thank you, Ms. Griffin. Any questions? Senator Orrak, number 5.
Thank you, Mr. Chair. Thanks for your comments. Good to see you again. Ella,
Just bring it a little bit closer to you. There you go.
and the masks don't help, do they? Why do you have to change the law to do what you want to do, which is care for expectant mothers and their minor children?
Well, there's definitely all kinds of ways to do this. The Morning Center is an example. Just churches in general caring for family members and friends that they have. We're just following the leadership of Senator Robertson on this kind of legislation
So we
that
can
he
reserve that
believes would
question
help
for
us.
Senator Robertson when he gets back up. That'd
Yes,
be
sir,
great.
that would
That's
be
no
good.
problem.
He could answer that as
Thank you.
well. But thank you.
Sorry.
Any
Mr.
other
Chair,
questions?
for this
That's okay.
silly phone.
That's all right. Sometimes those phones get in the way, don't they?
Amen.
Amen. All right, I like that.
Yeah, I'm trying to read here.
There we go.
Stuff's coming in. I
That's-
don't
I
usually
got
do
you.
this. I'm not.
All right.
Hey, I'm old school.
Thank you. We
I
appreciate
like
that.
paper.
Appreciate that, Mr. Griffin.
Thank you, Mr. Chairman. Appreciate it.
Elizabeth Reed. I think I can pronounce that name correctly. And Beth, I'm struggling. Is it Haythorn or Hathorn? But this is Miss Reed. Okay, thank you. The podium is yours. Just identify yourself, who you're with.
Is it okay if I take my mask off? Okay. I'm Elizabeth Reed. I'm with Georgia Life Alliance, GLA. We support this bill, obviously, because it, helps promote a culture of life. I know you guys have a printout with some data from Senator Robinson. So I won't repeat those data points to you because I know you can read. A lot of the reason we support this bill is because of those things, because we know mothers in crisis situations need help. But personally, when I was a teenager, I found myself pregnant and homeless. And a couple of the things that, the reasons the senator brought the bill was, to address maternal mortality and infant mortality. While I was homeless, I didn't obviously, knowing where my next meal was going to come from was, wasn't a very certain thing. I gained 7 pounds my entire pregnancy. My daughter was born 8 weeks early, and, just with the uncertainty of knowing, where you're going to sleep that night or where your next meal is going to come from, who you're going to have to sleep with in order to get it, where you're going to have to steal it from. I was arrested. I was put in a YDC. This bill would help a lot of things like that. When you're spending every day just trying to survive, you don't have time to hope. You don't have time to do anything like that. And we support this bill because we think that it addresses those needs and it would help women that have been where I was.
Thank you for your courage coming here and sharing your story with us. Do we have any questions from the committee? Thank you, Ms. Reed. Can Beth come in now for Whispering Hope, and then we have Larry Ramsey from ACCG. Thank you.
All right.
Floor is yours. If you pronounce your last name for us and who you're with, I would much appreciate that.
I'm Beth Hathorn,
Hathorn.
and I'm with Whispering Hope Women's Resource and Pregnancy Center from Cumming, Georgia. So thank you, Mr. Chairman and committee members, for giving me the opportunity to share with you why I believe the Maternity Supportive Housing Act is needed for Georgia. I'm the director of a nonprofit pregnancy center in Forsyth County. We provide medical services, education, and practical help to pregnant moms. So we see women all the time who are in need of housing. Besides the ways that we help them personally, we also connect moms that we see with other resources in our community and in our state. We do whatever we can to help these moms have what they need. But almost weekly, my staff meet with young women who are vulnerable. They're in situations where they lack critical support, whether it's financial support or family support or a home, a roof over their heads, who could really benefit from a maternity home, a safe, secure place where a woman can prepare for birth and then recover from her pregnancy. So housing is often one of the greatest needs that we see for young, single, pregnant moms. Knowing this, 2 years ago, my board asked me to look into what would it take for us to open up a maternity home. It would be a natural extension of what we're already doing. So from our experience in trying to get help for women who are pregnant and connecting them with resources in our state, we already knew that there was a lack of maternity homes to meet their needs in our state. So I began to research, okay, well, what is it going to take to open a home? And what I discovered was that the current rules and regulations for maternity homes are focused on taking care of pregnant youth, particularly those that are in the care of the state and those who have opted to stay under the state's care through the age of 21. So in order for my organization to provide housing to young adult pregnant women who are ages 18 and above, we would have to come under that definition and rules that are written for minors. That is the big issue that we have, because the women that we mainly see who really need this are women who are in that 18 and above, especially in that 18, 19, 20, 21, when they're in their early adult years, where they've not had the opportunity to really advance in their career, to get the job skills yet, to finish their education. They're at a disadvantage for taking care of themselves and a baby. So to give them a housing, to help them with housing, that at least they wouldn't have to think about, where am I going to have a roof over my head tonight? That would give them the opportunity to really focus on some other things so that they can be strong in order to take care of themselves and their baby. So, the issue here is all those rules and regulations. For us as an organization, if we have to come under all those rules and regulations written for minors, and we want to serve pregnant adults, it shouldn't be that way, because they're adults. We ought to be able to treat them like adults. My organization plans to open a maternity home, hopefully this year. We're on track to do that. We will serve up to 6 pregnant women at a time. We are not seeking funding from the state. Our home will be privately funded by individuals and organizations who care about our mission, who want to come alongside us and help pregnant women. The question that remains for our organization is, will we be able to serve women ages 18 and up, or will we be limited by the current definition and rules to serving women beginning at age 22? So we would leave out that vulnerable age group, because we're stuck with the old rules that shouldn't even apply. So passing the Maternity Supportive Housing Act would allow us and other organizations, because there's other organizations across our state who are wanting to open maternity homes, but they don't because of all these rules and regulations. So passing the Maternity Supportive Housing Act would allow us and other organizations in our state to open homes without needless oversight, and it would allow us to serve pregnant women beginning at 18 years old. So this bill, it's good for women. It's good for women. It helps women. It empowers women. And it is good for the state of Georgia. So I urge you to pass Senate Bill 116. Thank you.
Thank you, Ms. Hathorn. Do we have any questions from the committee? I appreciate that. So I think that probably answered a lot of some of the questions and concerns that we had from before. I appreciate your enthusiasm, what you do so much, and thank you. I'll venture out that, we use 18 as arbitrary, 21 as arbitrary. Probably most of the people here in the room know, they've heard me quote multiple times the frontal lobes and the maturity that we get as we get older, and it's probably not till 25 and 26 till we fully mature. I think the parents in the room can certainly appreciate that, and so we certainly appreciate what you do. Thank you so much, thank you. Larry Ramsey is next with ACCG. Mr. Ramsey, you got a hard act to follow there.
Absolutely, Mr. Chairman.
I know you didn't come opposing the bill. Maybe you did. Actually, I think it does say that. I won't be in attack mode. I apologize. So why don't you just identify yourself and who you're with and why you're here.
Thank you, Mr. Chairman. Larry Ramsey with ACCG, the County Association. And there is one portion of this bill that we are opposed to. As Senator Robertson said, I know he said he wasn't shocked that there's opposition from ACCG, and I think probably the lack of shock is that we do try to be consistent when it comes to proposed state legislation that would preempt local government control, home rule issues. Our opposition is not about the subject matter of this bill. This has nothing to do with housing for pregnant women. That is something we certainly support, and in fact, something that counties and cities actually have to take into account now under existing state law. The comprehensive planning law requires local governments to consider the housing needs of their community, all types of housing, whether that's this context or whether it's multifamily, whether it's senior housing, whether it's affordable housing. All of those have to be included in the periodic comprehensive plans that local governments work with their citizens on. And those are preconditions to getting any state funds or state permits, sewer treatment plant permits, et cetera. Any permit that comes from the state, if we don't have an approved comprehensive plan as approved by DCA, then all of that is off the table. So this is something that we take very seriously and have to, as it is now under existing law, and we certainly want to make sure that these housing options are available throughout the counties of the state. Our opposition is solely to the paragraph C that starts on the last page, starting at line 42, and that's the preemption paragraph that says that no local governments cannot treat this type of housing any differently than they would treat housing in which a related family resides. It's very common now in zoning ordinances throughout the state that in single-family housing districts, those districts will be defined to allow housing of related families or, again, very commonly, up to 4 unrelated individuals. Okay. Now, if you've got a zoning ordinance out there that, again, has been adopted by a county after input from its citizens that right now says up to 6 unrelated individuals could live in that housing, then the category of folks that are seeking to be protected by this law are already protected. Federal law prohibits us, counties, cities, from treating certain protected classes any differently than we would treat any other unrelated group of folks residing in one home. So whether that's pregnant women, because that's familial status under the Federal Fair Housing Act, or whether it's folks suffering from substance abuse, drug rehabilitation homes, et cetera. These are protected classes. We cannot treat them any differently than we would treat any other group of unrelated folks living together in one residence. But again, as mentioned, I think it's much more common throughout the state that zoning ordinances say up to 4 unrelated people, and this would expand that to 6. Why 4? Well, think about it from, again, the zoning and planning perspective. The idea of unrelated adults living together are going to have different impacts in a single-family neighborhood than a true related family with children, et cetera. You're going to have more vehicles, et cetera. But the point being not that this is a bad idea, but that that's the type of issue that should be resolved at the local county level. I believe, and I think you have a handout that I'd sent in, that this is one of those areas where there is likely a constitutional issue. You obviously have your own counsel, some of your lawyers yourselves. But unlike the general home rule provision, which is what we're usually talking about when you see ACCG speak on preemptions, that provision does allow the General Assembly to alter home rule authority. But in this case, the zoning provision of the Constitution says that the substantive power of land use and zoning lies with counties and cities of the state, and that the General Assembly's authority is reserved to procedures, how the local governments will implement those substantive powers of zoning and land use. Again, this is not about, opposition is not about the subject matter. It's about the division of authority that the Georgia Constitution sets out. We have categories that if we're not treating this type of housing at least as on even par, if not better than other unrelated groups, we're violating fair housing law right now. I've certainly dealt with those types of cases, not in this situation, but in the substance abuse housing, where you're not treating them as equally as you are other unrelated groups. So again, I appreciate the committee's time. Happy to try to answer any questions, and I hope you understand that counties are very sympathetic to the housing issue. This is about the division of authority set out by the Georgia Constitution.
All right, so we got some former county commissioners, right? Number 14.
Long ago and far away.
In a previous life.
You said 6 individuals in a house, but I guess there's not really a limit in this because it's 6 pregnant women and their children, so.
Well, that's right. And so what I would say that what I'm used to seeing, I guess, whether it's 4 or 6, as I read the bill that's before you, up to 6 unrelated women, and as you say, and any children that they may already have, they can be in one housing location and cannot be treated any differently than a related family as is.
And then a second question, this is probably more for the sponsor, but I'd like your opinion too. You know, we get to lines 46 through 49, we've got all that new language about registering and all that stuff, but then, and I need some help from the attorneys too, I guess, but it says nothing shall be construed to require them to register. Is that saying we've set up all these rules to register, but they don't have to register?
No. Remember, that was, I'm sorry, you may not have been here, but that refers to the maternity home and not maternities. So that's a different section of the law.
So they do have to register as a home, but just not under. Is that right?
So clarify. I mean.
Yeah. So right now, under the law, if you qualify as a maternity home, you do have to actually get licensed by the Department of Human Services. But a maternity home, in that definition, actually provides a lot more services like prenatal and that kind of thing. What this bill would do would create a separate category. This is just housing this would provide, and they basically just have to register. There's no licensure requirements or anything like that. They just have to submit an application and then the fee and the affidavit, and they're registered. So it's 2 different entities, although the terms are obviously probably a little too close, but that's 2 different things.
Okay, because it's saying nothing in this code section after it set out those rules through 45, But you're saying they do have to follow the rules through 45?
So it's saying that the current maternity homes, which are licensed, they don't also have to get registered under this code section. So
Okay.
it's like two completely different entities. One's licensed, providing a lot of services.
So it's not increasing the burden on maternity homes. They don't have to register under this section.
And these are in private residences, individuals' residences.
But we will know where they're at. They've got to do some sort of registration where you know where that, because that would be a concern as a county commissioner if you've got things that aren't registered or that say they are.
These would be registered
Okay.
under this section.
All right,
Senator
that's
Allen.
all my questions.
Okay.
Sorry. Just back to the point about the 4 versus the 6 unrelated families, and maybe this is also for Senator Robertson. So what we're saying now is that currently under the current code, up to 4 unrelated mothers and children can live in the same home. According to this bill, no services are going to be provided because it's not a maternity home. It doesn't provide prenatal care or anything like that. Without government oversight, it only provides the housing. Am I misunderstanding that if you just shrank the size of the home to 4 unrelated women, that we could be doing this already? Like, is there some difference? aside from
Senator,
the
I think I was
capacity?
unclear. I think I was unclear on the point I was trying to make about the 4. I was talking about zoning ordinances around the state, and they vary, just like there's
Okay. All right. Thank you.
different issues, different concerns around the state. In my experience, it's very.
We got you. We got you. Thank you.
Okay.
I think we understand it. Did I miss that? So different sections. You just use that as an example. Did you have a follow-up question?
No, well,
Okay.
It's really to Dr. Orrick's point. Senator Orrick's point is whether or not this requires a law.
And that goes back to Senator Robertson. Any other questions for Mr. Ramsey? All right, Senator Hatchett is on number 3.
Mr. Chairman, could you please expound on the constitutional argument that you were bringing up earlier about treating people differently and how that applies here?
So I think there were 2 different issues, Senator, and again, I apologize for if I was not clear. So on the constitutional issue has to do with zoning and land use. So right now, the Georgia Constitution says that the substantive power of land use and zoning lies with county governments and city governments. And the General Assembly can adopt procedures about how those zoning powers are exercised at the local level, but can't dictate the substance of land use throughout the state. So that's the constitutional issue. What I was talking about, unequal treatment, I think goes more to federal law. There's the Federal Fair Housing Act sets up certain protected classes when it comes to housing. One of those is familial status, and I think housing for pregnant women falls within that category. Local governments, states cannot treat any of those protected classes less favorably than they would treat any other unrelated group of folks that want to live together. Okay, so as an example that I've dealt with in the past, not in this context, a substance abuse house wants to locate in a particular community, and they want to have 4 unrelated recovering addicts living in this house. And that local government has an ordinance in place that says, well, 4 unrelated people can live together, but if you're a substance abuse house, you got to come get a separate approval from us. We're going to make you jump through more hoops to locate that type of house. Federal law, and the courts have been very clear on this, that's discrimination under the Federal Fair Housing Act. If you're going to allow one group of 4 unrelated folks, again in this example, to live together, but you're going to put more burdens on a protected class under federal law, then you're violating federal law. Okay, so I hope that explains a little better that there's the Georgia constitutional issue, but then there are also additional protections for this type of housing that prevents discrimination against them.
Okay, and Mr. Chairman, if I can follow up with one more question. So my understanding, and what you're saying is it's not necessarily treating people different, it's discriminating against a certain class. And when the case of pregnant women in this situation, wouldn't we be giving them favorable attention here and not necessarily discriminating? And then it would be the other classes that would have standing to challenge the constitutionality of our treatment of pregnant women.
I would agree with that, Senator, that if this bill were to pass on that federal discrimination issue, yes, you would not be discriminating against pregnant women by this, but you would likely bring in other classes that would have to be treated the same way, yes.
Okay.
Thank you.
Thank you.
Any other questions from the committee? Thank you.
Thank you,
Ms.
Mr. Chairman.
Ramsey. Okay. Just from a point of clarification, if we could get, and Senator Robertson, you want to come back up, and then, Ms., you want to step up, Ms. Howington, the, okay. No, we're good. We were sidebarring up here relating to the, to that particular section. We're talking about lines 42, 43, 44, and 45.
That's right.
Okay. Do you mind just giving us a little bit of backdrop here?
Yeah, I just want to clarify, that provision is saying actually exactly what he was trying to say, that it's that this group isn't treated any differently than any other residents in, say, the neighborhood. So if there was a zoning provision that said you could only have 4 unrelated people in a home, that would also apply to this. This 6 is not going to override this. So it's saying that you can't make it, say, 2 unrelated people if it's a maternity housing residence. So it's in essence saying you can do the exact same thing, but only if you're doing it to the neighbors and the, that are in the same area. So, does that make sense?
And if I can say this, when the whole unrelated thing started coming about in all the counties, what we were having is we were having a lot of migration of certain segments of the community moving into certain parts of cities here in Georgia, and they were all unrelated. And they were renting very small houses in residential areas, and groups were moving in. They may have been there for a job. They may have been there because they were undocumented and all this, for a plethora of reasons. And counties started establishing these types of ordinances in order to manage those populations, because they were coming in and you'd have 6 or 12 male individuals living in a mobile home in one section of a community, and I'm referencing a part of Columbus. And so some of the owners of those properties started making complaints that they were renting to one person, but when they would go by and check their property, there'd be multiple individuals living there and they didn't know who they were. So they created these ordinances in order to manage those types of populations. When he discusses the federal law and how what we're trying to do pushes back against that, and that what we would do here in the General Assembly would violate the county's free rule or opportunity to make those decisions. The legislation itself says that they have to adhere to the residential zoning. It says they have to adhere to I just want to make sure I say the right. In compliance with applicable residential building codes on line 35. And what we have found, and we attempted to do this in Harris County earlier this year with putting a home for 12 victims of sex trafficking on 100 acres actually there. And what we have found, and I want the gentleman to understand, I have no axe to grind with ACCG. I've just dealt with ACCG over 30 years working for Columbus, Georgia, and I understand what their role is. But what they want to do is they want to push these types of housing into areas, and if they use the federal laws, then they'll want to come through and have sprinkler systems and all these other prohibitive infrastructure, basically in order to discourage nonprofits from putting these in areas that psychologically are much more comfortable for this vulnerable population. And so while I appreciate the fact that, that counties want to keep a tight grip, the section of the Georgia Constitution that he references, in my non-law school mind, I feel gives the General Assembly the right to adjust some of those things to ensure that individuals and nonprofits especially are able to establish these types of residences. And as many of the comprehensive plans I've ever sat in and listened to, I've never heard this category discussed. I've heard affordable housing. I've heard, commercial. I've heard all this.
All right, I think you had us.
But-
I
well-
appreciate this. The sprinkler aspect I think, drives the point home.
Yes, sir.
I'm a non-lawyer. I'll be happy if the lawyers on the committee if they're comfortable with that. I'm comfortable with it. I don't think it's unconstitutional. So I'm amenable to an amendment as in line 16 after they're putting minor. And then on line 37 after other putting minor. And then on line 36 where it says C has property insurance, striking the word property and says has insurance coverage. Those would be three simple changes. I would be willing to accept that as an amendment if the author is, and we can move this forward if that's what the author so chooses.
Absolutely, I concur
That
completely.
to me sounds reasonable. They're not onerous changes. Those are not complicated changes. We have a so move. We have a Senator Walker is deferring to Senator Hatchett. Is that what I got with that nod?
No, I wanted to comment on the insurance issue.
Okay, let's do that. Let's get a second, and then we'll have a discussion on that. Okay, second by Senator Hatchett, and I appreciate if Senator Walker can help us with that.
Okay, on line 36, I sort of thought the intent would be for the owner of the house to have property coverage on the house. So to me, the amendment should just be has property insurance coverage on the residence, period. But if you say has insurance coverage on the residence, which covers the residence, newborn, and other children, I don't know if you're talking about life insurance on them, if you're talking about health insurance, if you're talking about property coverage for their personal property.
Listen, I really appreciate this discussion. So we've had lawyers question, and we got legal, they got the insurance. You want to amend your amendment?
To end that sentence after the word residence, which would then make it unnecessary to add minor children to the rest of that sentence.
Let me get our legal counsel here. Okay, so would you mind reading that to us, please?
Right, so then line 36 would just read, has property insurance coverage on the residence, period.
Is the author good with that?
Yes, I am.
Okay.
Yeah, I apologize, Mr. Chairman.
Okay, so let me be clear. The amendment, why don't we do this? Why don't we table the First Amendment and go back and does anybody have a motion to table the amendment that we just did, and let's go back and do it right? So moved. Second. All those in favor say aye. All those opposed, like sign. It's unanimous. All right, so if it's okay, I will propose the amendment, and the amendment's going to be the 16, line 16, and their minor children. And then on line 37, newborns and other minor children. And I'm going to get Ms. Howerton to state the line 36, if you don't mind, please.
Well, and actually, the second thing you just said will be moot.
Oh, it will be removed,
Yeah.
wouldn't it? Yes.
So
All right.
I think what y'all are talking about, if I may, is on line 16, adding the word minor in front of children, and then on line 36, having it read, subparagraph C, has property insurance coverage on the residence, period, and then striking the rest of line 36 and all of 37.
That's why she went to law school. There we go. All right, and we got a motion from Senator Kirkpatrick, and do I have a second? Second, Senator Hatchett. All those in favor of that amendment, please say aye. All those opposed, say nay. Okay, and so we had the amendment, so this will be, we'll consider a motion for LC 338570, that's Senate Bill 116, as amended in committee. Do I have a motion on that? Motion, Senator Hatchett, second. I have a second, Senator Burke. All those in favor say aye. All those opposed, like sign. All right, let's do a hand count then, if you don't mind. Let's do, all those in favor, let's raise your hand. Okay, so 1, 2, 3, 4, 5. Did I do that? 1, 2, 3, 4, 5, 6. Okay, and all those opposed? 1, 2, 3, 4. Okay, the motion passes. Thank you, Senator, for bringing this.
I really appreciate your help, Mr. Chairman. I appreciate the help of the attorneys, and Senator Walker has walked the fire twice today, and I appreciate him a lot for that. It means a lot. It really does. I'm serious.
As Eric Russell used to say, big team, little me, right?
That's
Gotcha.
it. That's
Okay,
it.
thank you so much.
Thank you, sir.
Meeting is adjourned.